Hello friends, very warm welcome to my Business Laws channel. For this IT Act friends, I have already made one video of IT Act, that was lecture 1, where I have covered objectives, non-applicability of the IT Act, and then apart from that, digital signature, meaning, uses, authentication of digital signature, private key versus public key, digital signature versus electronic signature. And then after that, e-governance and the provisions which promote e-governance. So this is the second lecture to this IT Act 2000. So in this video, friends, first of all, I'll be sharing, I'll be talking about the various questions which have been asked in DU and other examinations from this chapter. And then, I will discuss those questions. And the chapter's title is Attribution, Acknowledgement, and Dispatch and Receipt of Electronic Record. Now, frequently asked questions. These 3 questions have been asked in DU examination and other examinations, professional examinations. When is the electronic record said to be attributed to the originator? And the second question is, discuss the rules relating to acknowledgement of receipt of electronic record. And the third is, describe the rules regarding time and place of dispatch and receipt of electronic record. So the very first heading is, friends, attribution of electronic record. Now, what is the meaning of the term originator? And what is the meaning of the term addressee? A person who sends, generates, stores, or transmits any electronic message is known as the originator. And the recipient of the electronic record is called the addressee. So originator is the sender of the ER, electronic message or electronic record, and recipient is the addressee. But remember, friends, recipient or sender, addressee, and the originator are different from intermediary. Now, I would like to explain both the terms with the help of example. Say A has sent mail to B. A is the originator and B is the addressee. Now B has replied to that mail which he received from A person. Now B is sending the mail now. B becomes the originator and A becomes the addressee. So we can say, friends, one person could be the originator for one electronic message and the addressee for the other. As A was the originator first and second time he was the addressee. Moving ahead. Now, when is the electronic record said to be attributed to the originator? So friends, the answer for this question has been provided under Section 11. Section 11 of the IT Act 2000 provides electronic record could be attributed to the originator in 3 ways. First one is when it was sent by the originator himself. And second was by any person who has such authority. That is, it was not sent by the originator, but originator authorized somebody to send that document. And the third is by an information system programmed by or on behalf of the originator to operate automatically. So friends, intermediary is Gmail. So we are having originator, we are having addressee, and then intermediary Gmail. Programmed info system when on a trip outside. See friends, the third point which I have talked about, information system, it is programming is done which operates automatically. Say, A has received some mail. Now he is busy, he has planned a tour, and now he arranges this program, he inserts a program, and then this information system program will work automatically. That is, he has set that he is on a tour now. When he will come back after 10 days, then he will apply to his mail. So in this way also we will say the electronic record will be said to be, attributed to the originator. Now, moving ahead, friends, the second question is, friends, regarding acknowledgement of receipt of electronic record. Now, which are the rules regarding acknowledgement of receipt of electronic record? These rules have been provided under Section 12 of the IT Act 2000. First point is where the originator has not agreed with the addressee about the form of the acknowledgement of the receipt of a record. He has not agreed. Originator has not agreed with the addressee. Then what is the provision relating to the acknowledgement. There are 2 points here. Any communication by the addressee, automatic or otherwise. Any communication which is sent by the addressee, it reveals that the document was received by addressee. This is in a way the acknowledgement. And second is any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received. Say originator has sent the mail and he has asked for some information, and now addressee has sent that information. So it is understood, friends. It indicates that addressee has received that document. And second is a point where the originated electronic record shall be binding only on the receipt of the acknowledgement. In such a case, unless the originator has received an acknowledgement, the ER will not bind him. So friends, here the originator is very particular about the acknowledgement. In case the addressee does not acknowledge the receipt of ER, then originator shall not be responsible because he wants the acknowledgement to be sent. Moving ahead, where the originator has not stipulated anything and the acknowledgement has not been received within a specified time or within a reasonable time. So acknowledgement must be sent within a stipulated time. If time is specified, if time is not specified, then within a reasonable time. And if the acknowledgement has not been received at all, neither within the stipulated time nor within the reasonable time, then in that case the originator can send the notice to the addressee to treat the ER as if it has never been sent. So friends, here we will say that then the originator will not be liable because he was wanting acknowledgement. Acknowledgement has not been sent. There was failure on the part of addressee, and now he has served the notice to the addressee that he will not be liable now. He should treat as if the document was never sent. Now this was the answer for the second question. And now the third question is, what are the rules or provisions relating to time and place of dispatch and receipt of electronic record? Let me talk about time of dispatch and time of receipt, and then I'll be talking about, place of dispatch and receipt. Time of dispatch, section 13, subsection 1. Time of receipt, section 13, subsection 2. Section 13(1) provides a record is deemed to have been dispatched by the originator at the time when it enters a computer resource. The moment it enters the computer resource, it is deemed to have been dispatched by the originator. Now, time of receipt. What is the time of receipt now? It shall be determined as follows. The three situations. First one is where the addressee has designated a computer resource for the purpose of receiving ER. Now the computer resource has been designated. Second is if the ER sent to a computer resource of the addressee but is not the designated one. Receipt occurs at the time when the electronic record is retrieved by the addressee. And the third point is where the addressee has neither designated a computer resource nor specifies the timings. The receipt occurs where the electronic record enters the computer resource of the address. So the moment the ER enters the computer resource of the addressee, it is said, it is deemed as it has been received by the address. That is taken as the time of receipt of ER. Now coming to the next heading, which is place of dispatch. Place of receipt. What is the place of dispatch? And what is the place of receipt? In the absence of contract to the contract, if there is no contract to the contract, if nothing has been decided between the originator and the addressee, an ER is deemed to be dispatched at the place where the originator has his place of business. So main is the place of business. Wherever the originator has the place of business, at that place is deemed to be the place where the document ER has been dispatched. And in the absence of any contract to the contrary between the originator and the addressee, an electronic record is deemed to have been received at the place where the originator has his place of business. Has been received at the place where the originator has his place of business. So where the addressee, it should be addressee has his place of business. So friends, one thing is very common in both the cases. When we talk about place of dispatch, then originator's place of business, and when we talk about place of receipt, it is addressee's place of business. Now, what is the meaning of the term place of business? There are certain rules which have been provided under section 13, subsection 5. The first rule is if the originator or the addressee has more than one place of business. In that case, the principal place of business shall be the place of business. If either the originator or the addressee, they have more than one place of business, then whatever is the principal place of business, that shall be the place of business. If the originator and the addressee does not have place of business, then his usual place of residence shall be deemed to be the place of business. The usual place of business in relation to a body corporate means the place where it is registered. So addressee or originator, they are the body corporate. Then the place where the body corporate is registered. One thing I would like to add here, since only secure electronic records and messages form a valid basis for determination of legal rights and obligations of the parties by the court, IT Act 2000 contains the legal presumptions relating to security of electronic records and electronic signatures. Only the secure documents, secure ER, secure signatures, they are entertained or they are considered, in the courts under the IT Act 2000. Secure electronic record. What does it mean? Section 14 lays down that where any security procedure has been applied to an ER at a specified point of time, then such record shall deem to be secure electronic record from such point of view to the point of verification. So friends, nowadays the system of electronic record plays an equivalent role to paper-based record. So the online document is as valid as the paper-based document. Both are equally effective. Okay, so friends, this is all from my side. I've answered all the 3 questions from in this video, lecture 2 to the IT Act 2000. I hope you will watch this video and will understand the content. If you have any doubt, do write in the comment section. I will surely reply. So friends, this was all from my side. So do press on the bell icon and get notifications of my future videos. Do subscribe to my channel if you have not subscribed yet. Stay positive, keep smiling and stay blessed always. Okay friends, goodbye.